practice in Monroe County, where this case is from. I'd like to reserve 5 minutes, if I could, for rebuttal if necessary.
Absolutely.
There are 3 issues in this case that we would ask the court to consider. The first concerns the sufficiency of the search warrant, and the question there is, if you have a document, is it automatically valid? Because there is no corroboration of the information by law enforcement that Mr. Keyt resided at the address that was stated, merely the words of the informant. There were talks about when information was given within 72 hours or knowledge within 72 hours, but there was no statement by the officer concerning whether the second confidential informant, because there were 2, had any knowledge of meth, only that she'd been involved in transactions where meth had been found, but not that there was any knowledge of meth. So we suggest to the court that, one, is that if you look at the testimony from Dalton Reinhardt at the suppression hearing, that Mr. Keyt didn't live at 209 Fire Department Road, that he came by and visited that location because there was talk about the car. So the officer knew when he started that the informant's information was incorrect about residing at that location. Also, if you look, as you can do, at the testimony that was presented at trial, there were no drugs found in this residence. There were drugs found on Mr. Keyt's person, but there were no drugs found in this residence. There was also paraphernalia found on another individual who was present at that residence.
What did the warrant, remind me, what did the warrant say with regard to the second confidential informant?
Your Honor, specifically, the court says, within the past 72 hours, I was contacted by a confidential source of information referred to as SOI-2. Okay, so that was when the officer was contacted. SOI-2 stated to me that Chris Keyt is selling methamphetamine in Monroe County, Tennessee. That's very general. Monroe County is, I believe, the 5th or the 6th largest county in the state of Tennessee. We give that information in our reply brief. SOI-2 stated to me that Chris Keyt is living at 209 Fire Department Road in Sweetwater, Tennessee. And that's the address that the search warrant was given to. And that SOI-2 stated within 72 hours, we don't know 72 hours of when, because there are 2 references to 72 hours. One is when the officer got the information, and the other is to when the SOI-2 got that information, and observed Mr. Keyt in possession of multiple ounces of ice methamphetamine inside the residence. Then it goes on in the next paragraph, and it says basically that she has given information that resulted in drug arrests and has led to discovery of illegal controlled substances, including meth. But never does it say that she had any specific knowledge of what meth was, used meth, been involved in any knowledge of that necessary. And we submit that that should be held, because otherwise anybody who's involved in the drug culture can say, well, there's drug culture here, we can say it's meth, and go forward. It's strictly
It did say that the confidential informant had been involved with meth cases before.
I'm sorry.
It did say that the confidential informant had been involved with meth cases before.
No. It says
Okay, I thought you read that.
The confidential informant has participated in multiple prior controlled buys. Information provided has led to the arrest of no less than 6 individuals for drug-related crimes, along with the conviction of drug-related crimes, not meth, nothing else. And then it says has led to the discovery of illegal controlled substances, drug paraphernalia, and drug proceeds, including methamphetamine, marijuana,
Okay, I thought it said meth somewhere in there.
Their meth was in, the mention of meth was there. But it is if you're preparing an affidavit of this nature, it's very easy to say that she's aware of the contents. And you see it on a regular basis, that the person is aware of what meth is and has gone forward. These paragraphs are carefully worded to not refer to that information.
Mr. Jolly, can you remind me what the reasoning of the trial, I'm sorry, I'm relaxing. Can you remind me what the reasoning of the trial court was in denying the motion to suppress?
The reasoning of the trial court, Your Honor, in this area was that there was sufficient corroboration under the current
Just,
rules.
it didn't make any specific findings. I haven't really gotten into the record.
No. The specific findings, and we'll address this because we do have an issue concerning the search of the vehicle that was at the residence, where there is no reference in the search warrant to the search of a vehicle. And we argue that that is required. The state of New York does not, and we cite that in our brief, does not allow the search of a vehicle on a premise unless the vehicle is specifically mentioned as one of the items that should be searched. The trial judge recognized that, but held that that was discovered in plain view. And so we would submit, Your Honor, that once you're there, it allows you to essentially do what you want to do. And we would submit that our Constitution protects us in our properties and other matters, and that if we are to be protected, that we need to have that specific notation given in the search warrant. It's very easy to do. It's part of a form in most of them, but this form does not have that. Just like this form does not say that Dalton Reinhardt confirmed that Mr. Keyt was living at this residence, because in fact, Your Honor, Dalton Reinhardt knew that he was not living at this residence. If you look and see what actually happened on the search in this case, Officer Reinhardt was waiting in the woods to see when Mr. Keyt pulled up and then got the team to come in. So
I thought there was some proof that the officer, while waiting in the woods, saw Mr. Keyt go back and forth to the vehicle where the gun was
yes.
found.
Pulled up, gone back and forth to the vehicle. Yes, that's correct, Your Honor.
Okay. So it wasn't like they were just waiting and the minute he drove up, they swooped in? Not exactly that.
You can read it both ways, Your Honor.
Okay.
And the part of the issue that we have when coming in trial in this matter and looking at that is once we get to trial, the trial judge allowed Dalton Reinhardt to be declared an expert witness in drug investigation in Monroe County. We had no notice that he was an expert. We had nothing that showed any type of expert report. We did have a lengthy hearing about it. The judge held he was qualified, even though under McDaniel versus CXX, he didn't meet any of the qualifications for expert witnesses. And of course, we're going to hear from the state that that's discretionary with the trial judge, and yes, that's what the case law suggests, but we would ask the court to do this. One is to require notice if there's an officer who's going to testify of this nature, and two, to require what is called a dual instruction in the federal court that requires the consideration by the jury of the officer's dual role. Because if I might use language, the judge blessed his testimony by declaring him an expert.
But there's not any, is there any Tennessee case law
No,
requiring
there
that
is
dual
not.
instruction?
And
I mean,
the
I've had
only-
some cases where.
And the only cases that say it's not required under Tennessee law because the expert instruction about consideration was given, and it was given in this case. We're asking the court to go further and
Well, we
require.
can't,
Yeah.
we can't say the trial court erred when the trial court followed the law. And
The court can uphold that portion of the ruling if you want to and suggest it might be a better practice to do the other thing.
Understood, Mr. Jolly.
And so that's all we're asking for once you look at it. And it is very difficult when you're trying to deal with a law enforcement expert when the only expertise they have is exactly what they're testifying about in the case. And when you are not allowed to cross-examine that witness about the type of expertise that they are talking about in the case, that is how they treat informants. Officer Reinhardt testified about that. We had a letter that was filed by one of his informants in another case concerning what treatment she had. and we were refused to allow to cross-examine.
Well, how is that relevant regarding really this case or even Reinhardt's
I would suggest
expertise? I mean, honestly, how is that relevant?
You have proved our point is that how is his testimony as an expert witness relevant, because it wasn't.
Well,
And
I'm
how
asking
is
you
his
how that letter from a disgruntled CI was relevant to the issues
Because he
here.
testifies about how well he treats CIs and how we need to protect them, why that was relevant
How
in
is
this
that relevant
case.
to his expertise?
It's not, Your Honor, it's
Okay.
not. But that's what I'm hearing. That's what the testimony was about, and yet when we bring this other letter in about how she had been treated, and the court said no. So it's kind of a goose and a gander rule under the circumstances that we're tired of being the goose and like to be the gander occasionally, Your Honor. And the last issue I would like to address, Your Honor, is the issue concerning the sufficiency of the evidence in the case. We have a unique statute for the sale of meth, and it specifically says sale of meth is punishable by law. No objection to that. Then it refers to a prior statute that it replaced to say what the punishments were. And there are two punishments listed. One is for a substance containing meth that is greater than half a gram. That's a greater punishment. Carries 8 to 30 years under appropriate circumstances. The other punishment statute says that not a substance containing, but that the meth is less than half a gram. So that's a Class C felony. So you've got a huge difference between what should happen. In this case, the indictment said that he possessed with intent to sell greater than 0.5 grams. And the court said, oh, that's okay, it may be wrong language. I will tell you that form indictment, and Judge Montgomery probably recognized this from his days as a general a long time ago. That's the same form indictment that's been used for years, and it's wrong.
Was there an objection?
Absolutely, Your Honor. We said that the indictment charges and requires the state to prove more than 0.5 grams. And the response was, the statute doesn't require that. I don't have to charge that. The jury's going to be charged like this. But that's where the confusion comes in, because the statute does require that it be less than 0.5 grams of meth. And the lab says, we don't do that testing. We don't do purity testing. We tested no more than 0.1 grams to determine that it was a substance containing. We don't do purity testing. Well, we would suggest that if they are making a distinction between the two, and again, maybe I've been here too long, because they used to do purity testing back a long time ago, and they stopped doing it. But the federal sentencing guidelines require purity testing, because that has to do with the appropriate punishment, just like our statute has to do with the appropriate punishment. So we've got testimony in this case that there is less than 1/10 of a gram of any substance containing meth, and yet the jury was allowed to convict of the substance containing greater than 5 grams. Of course, the total weight of the substance, it's not misleading, is 11.3 grams. That was what was found in Mr. Keyt's pocket. But we suggest to the court that the proof actually shows that the C felony should be the conviction offense rather than the B felony, because of the nature of the toxicology testimony. And we refer to the court to Judge Tipton's opinion, where he was talking about back when meth used to be constructed in bottles and jars and what was the weight of the jar and what was the weight of the meth, where he said that it was only fair under the circumstances to consider the actual weight of the meth and reduce the offense. The other brief point concerns whether the gun was actually used during the commission of or attempt to commit a drug felony. There's no proof that Mr. Keyt had the drugs in his pocket at the time that he was going back and forth to the car, as it was noted. We will reserve any time that we might have. Thank you.
Thank you, Mr. Jolly. General?
Good afternoon, Your Honors. May it please the Court. Garrett Ward here on behalf of the State of Tennessee. Your Honors, this Court must affirm the judgment of the trial court below because the evidence does sufficiently support both of the defendant's convictions, because the trial court properly denied the suppression motion raised by the defendant pretrial, and because the court appropriately dealt with the expert testimony of Detective Reinhardt, both in terms of qualification and on a sort of pseudo 705 issue. I'll address the issues in the same order as Mr. Jolly did, but before that, Your Honors, because sort of the fact-intensive nature of probable cause supporting a search warrant and the fact-intensive nature of sufficiency questions, I think it's useful to sort of briefly run through the facts of this investigation, what was in the search warrant, what happened when the search warrant was executed. And really, Your Honors, where this case all starts is with information given to Detective Reinhardt by two different confidential informants. The first confidential informant gives, frankly, some fairly general information. Sort of the upshot of the first confidential informant's statement is that Christopher Keyt is selling methamphetamine in Monroe County. However, there is a second informant with much more specific information, both as to what Mr. Keyt is selling, where he's selling it, and when he has been selling it. And what the second informant says is that within the past 3 days of talking to this officer, that this informant was inside a house at 209 Fire Department Road in Sweetwater, that he observed Christopher Keyt selling methamphetamine, that Mr. Keyt was at least was residing in this home, and that elsewhere in the home there were additional amounts of methamphetamine. So that's where this case really starts, is these two informants. When the second informant comes to Detective Reinhardt, he, within 3 days, seeks a search warrant. The information he provides in that search warrant is chiefly the information related to him by the two confidential informants. He does, however, provide some pretty critical information about the second confidential informant, who's frankly has given the better information, is really the foundation of this investigation. And what Detective Reinhardt explains is that this informant is a known entity to the Monroe County Sheriff's Department, that this informant has given them information before, that information given by this informant has led to, I believe it's six arrests, six different people being charged, led to the discovery of drug paraphernalia, drug sale proceeds, and controlled substances, including, critically for this case, information from this defendant has led to from this informant has led to the discovery of methamphetamine. Officer Reinhardt goes on to say that essentially every time the Sheriff's Department has acted on information provided by this CI, it's proven to be founded, at least in some degree. I believe the specific phrase he uses, their information is proven to have never been false, is exactly what Detective Reinhardt says. He also provides some information just about his own expertise and knowledge of
All of this is in the affidavit?
Yes, Your Honor. Paragraphs 4, 5, and 6 of the affidavit. Paragraph 4 is the first confidential informant. Paragraph 5 is all of the information given by the second confidential informant. Paragraph 6 is Detective Reinhardt discussing his past history with this informant, and I believe that is Exhibit 1 to the suppression hearing. So that's really the upshot of this affidavit. Based on that, the trial court issued a search warrant for the home at 209 Fire Department Road. When Detective Reinhardt went to execute this warrant, before just charging into the house, he surveilled it for some period of time. And what he observed while he was watching this house is the defendant on no less than 3 occasions, so at least a few times, the defendant leaving the house, going to a tan SUV that is parked in the front yard. Loading or unloading is the action that it appeared to the detective that the defendant was taking, and then going back into the house. So he repeats this process a few times. After one of these cycles, the detective goes to execute the search warrant. As he walks by this SUV, he looks in the window and he sees in plain view, and there's a photograph that essentially encompasses what the detective's view would have been, just the butt of a handgun sticking up from in between the front seat and the center console. It's easily visible from the driver's side window, and that photograph is the 3rd exhibit to the suppression hearing. He then executes the search warrant. While executing the search warrant, finds a little over 11 grams of a substance containing methamphetamine on the defendant's person, $1,600 in cash. And then when collecting the gun from the car, they also discover a couple of sets of digital scales with sort of a white crystalline substance. And in short, Your Honors, that's the investigation in the case. Now, as to applying, looking at those facts in the context of the 3 legal issues, first, when it comes to the search warrant, I think really the important thing to focus on here after Tuttle is sort of a common sense, practical approach that looks at the totality of the circumstances. For the past, 7 or 8 years now, Tennessee has stepped away from this really rigid mechanical Aguilar-Spinelli or Jacquemin test that sought very specific information, provided some very specific boxes that had to be checked in every search warrant based on a confidential informant. Tennessee has abandoned that test and instead asked trial judges and indeed this court to use common sense, to look at everything that happened, to look at all the information, and conclude whether or not there's probable cause. And in this case, Your Honors, the easy answer to that question is yes. The centerpiece of the affidavit, the centerpiece of the case for probable cause, is information from an informant who has been, determined to be reliable in a number of cases. This is not an unknown entity. This is not some figure coming in from the cold that the Sheriff's Department has never dealt with before. This is an informant that they've relied on in the past, and every time they've relied on this informant has provided them valid information. That's exactly what we have here. So we have a reliable informant who's saying specifically at 209 Fire Department Road, I saw this specific defendant, Christopher Keyt, selling this specific narcotic of methamphetamine. And I saw, a quantity of methamphetamine, outside of the individual sales that would, lead a logical person to conclude that there will probably be more sales there. Essentially, the affidavit essentially says Christopher Keyt is here selling methamphetamine, and there's another pile on the table. And then that affidavit is taken before the trial court with at least a little bit of buttressing of what the second confidential informant says in the statement of the first confidential informant, who is also indicated, albeit in much less specific terms, that Christopher Keyt is selling methamphetamine. And I think why that matters, Your Honors, in a totality of the circumstances context is what this means is that the statement of the second confidential informant is not some bolt down of the blue suggestion that Christopher Keyt's selling methamphetamine. This is something that has been mentioned to them before. They didn't necessarily act on it, but now that there is a reliable informant that they trust with specific information in terms of location and time, they do seek a search warrant.
Didn't the trial court say that the confidential informant one, that little blurb of information was old and stale?
They do say that, Your Honor, and frankly, under a totality of the circumstances approach, that's entirely appropriate. Certainly, the age of this information really limits the amount of use it could have in this sort of totality of the circumstances inquiry. But I do think it at least offers some support for what the second confidential informant ultimately comes and says. But it is, frankly, unneeded if the search warrant were nothing but this specific statement from a demonstrably reliable informant. The state would have had a sufficient case for probable cause just on that. And the trial court, frankly, pays very little attention to what the first confidential informant says. The defendant really focuses on, as I see it, their main problem with this search warrant is the supposed lack of confirmation. You know, I take that to be sort of a lack of excess or additional investigation done by the sheriff's department in this case. And Your Honors, that's simply imposing a legal requirement that isn't required. The department comes to this judge with information from an informant that is specific as to time, location, controlled substance, and seller. This is an informant who they know to be reliable, that they swear under penalty of perjury is reliable. The court could easily conclude and properly conclude that there was probable cause here. Briefly, as to suppression of the gun, Your Honors, I think Exhibit 3 really speaks for itself as far as the conclusion that this was in plain view. What Officer Reinhart says at the suppression hearing is that sort of as he was walking to execute the search warrant, he looks in the window and sees the gun. And unlike a lot of plain view cases, Your Honor, we essentially have a snapshot of his view and the gun is there. It is plain. He was in a place he had the right to be. He saw something he knew to be contraband because he does explain at the suppression hearing that he knew Christopher Keyt to be a felon at the time. So he certainly had every right under the Constitution to seize it on that basis. So this isn't some situation where the state is asking this court to give law enforcement sort of the license to just search through anything they see on a premises when they get a search warrant for a home. That's not the case here. This neatly fits within plain view of, if nothing else.
What about the, jumping ahead a little bit, the sufficiency argument of how the gun was used during the sale of methamphetamine, since it was in the vehicle and the defendant was inside with meth in his pockets?
So I think my main response on that, Judge Ayers, would be the testimony of Detective Reinhart that immediately before executing the search warrant, this defendant is sort of cycling between the house and the car as if he's loading or unloading it. So this is testimony in the light most favorable to the state. The defendant is in this car either getting something out of it or putting something into it right before he's arrested. Detective Reinhart does offer some additional testimony from his position as an expert, and I can get into his expertise in a moment, but from his station as an expert that this sort of proximity of handguns to the drug trade is pretty commonplace. So we have a defendant with contraband on him who's arrested with contraband on him, who minutes before being arrested is inside this car where the gun is located. So I'd suggest to the court that in the light most favorable to the state, this possession with intent to go armed during the commission of a dangerous felony, which possession of methamphetamine with intent to sell certainly is, that this conviction must stand. I'll briefly touch on the sufficiency of the methamphetamine conviction itself. Your Honors, what the defendant is essentially trying to do here is impose an additional element on the state here. Both relevant statutes, 417 and 408, talk about a substance containing methamphetamine. That's exactly what we have here. The weight of the substance, all the parties agree, is 11.33 grams. So really the defendant's argument is asking for this purity test, which I take it from my opposing counsel's statements is taken from the federal sentencing. That, of course, has very little part to play in the sufficiency of the evidence for a Tennessee crime. To briefly address his reliance on this Tennessee case dealing that sort of unpacks a little bit the substance containing language, the opinion written by Judge Tipton that my friend on the other side referenced. What this court recognized there This was a time when methamphetamine was made by shaking it up with brake cleaner. This court quite logically concluded that the brake cleaner was not sort of a byproduct or part of the ultimate narcotic being produced. It's just essentially just a tool, and wisely noted that brake cleaner can't be ingested, that the methamphetamine can't be consumed until the brake cleaner has been removed. So said in that case, we can't consider the weight of brake cleaner when it comes to the weight of the substance containing methamphetamine. It's not what we have here, Your Honors. We have what from all the evidence in the record suggests is just normal methamphetamine in powder form discovered in a baggie that we would expect it to be immediately used. It's not mixed in with some additional toxic or hazardous substance beside methamphetamine itself. The total weight of this substance was on the table to be considered, was properly considered by the jury. The evidence is more than sufficient to support the conviction of the higher graded felony here because the weight is 11 grams, which is greater than 0.5. Lastly, as to this issue concerning Detective Reinhardt's expertise, Your Honors, this issue mimics arguments that have come up before this court a number of times where a person is giving expert testimony not in a scientific field. While sort of the bellwether case in Tennessee for expert testimony, McDaniel, which is non-exclusive, which provides non-exclusive factors, is really crystal focused on expert testimony, on scientific subjects. Most of the McDaniel factors explicitly allude to scientific evidence or scientific testing. All of them, at least implicitly, are considering sort of science being done. 702 is rather broader than that. Says if an expert with sort of any technical knowledge from education or experience or otherwise knows more about a subject than the everyday person is likely to, they can testify as an expert. Your Honors, Detective Reinhardt here testified as to multiple collegiate degrees in the field of criminal justice with specific coursework on narcotics investigations. He spoke to numerous on-the-job trainings from regional and state law enforcement agencies that spoke to how narcotics investigations and narcotics trafficking were occurred. And he had been a law enforcement officer for, I believe, 7 or 8 years at the time of trial, with at least some of that time specifically in a drug unit. Your Honors, I'd suggest to the court this gives him quite a bit more knowledge of methamphetamine trafficking than the everyday juror has. I'd suspect the everyday juror has rather little knowledge of how methamphetamine is made, used, produced, or sold. Detective Reinhardt, because of his knowledge, experience, time on the job, he does have this sort of excess knowledge, and he was properly certified as an expert based on it. As for this letter, Your Honors, as I understand the argument as it was raised in the brief, what the defendant is saying is that he should have been allowed to use Rule 705 to cross-examine Detective Reinhardt with this letter, which is this document of questionable provenance from an informant making some pretty serious allegations against Detective Reinhardt. But what 705 allows for is sort of cross-examination, probing of credibility and expertise with reports, facts, figures that the expert relied on in forming his opinion. So really the operative question in this case that was asked of Detective Reinhardt at trial is, did you rely on this letter accusing you of paying a confidential informant in drugs to form your opinions about the drug trade? He says no, unless the trial court utterly disbelieves that answer, which given its ruling it clearly didn't. That's the end of the inquiry. He didn't rely on this information. It's not appropriate under 705. I'll very briefly touch on this suggestion that some sort of dual instruction is required. A couple of points on that. It wasn't raised in the brief. It is sprouted here at oral argument, and as this court noted, and my friend on the other side conceded, it's simply not the law in Tennessee, and we can't this court, and no party really can wag its finger at the trial court for not following a law that simply isn't the law in this state. Unless this court has further questions, I'd ask that you affirm.
Thank you, General Ward. Mr. Jolly, would you like your rebuttal time? Yes, sir.
Your Honor, if I could address, we make a big deal about this search warrant, and I guess I'm the only one here who's seen the amount of search warrants that Detective Reinhardt uses, and I know specifically what is omitted in those search warrants and how they're done. And the omission that we start with is, how do the police know that Mr. Keyt's at that residence? And what we have a glimpse of is during the course of the motion to suppress hearing that he saw the car drive, initially he says through town, and then he says in front of the residence a couple of times. He knew it wasn't Mr. Keyt's residence, just like the car wasn't Mr. Keyt's car. So if the issue is how do we get Mr. Keyt to a location that we can search, and therefore we can search him because he's named in the search warrant, then Detective Reinhardt did an excellent job of doing that. But we submit to the court that the court has said that Archibald is still valid law under the Braden case, and we would ask the court to consider those circumstances in weighing this. How do we know that there's anything left at the house? How do we know that anything was continued? Because we know that despite what it said about always providing valid information, that Mr. Keyt was not not living in that house in the traditional sense of living that we have. And how do we know that? There's nothing in the warrant that corroborates that Mr. Keyt lives there. No driver's license, no observations, nothing other than what is said by this confidential informant too. And the other difficulty when you refer, and the judge did say the information about number one is just stale, but the fact that you include that information is the same thing as saying it's rumored that Mr. Keyt sells meth in Monroe County. And that rumor's been going on for more than a year. So when we get the second information, we're going to follow up on it. And this is what we have. We don't have a residence because we can't observe it. We've got somebody who observes it who we won't specifically say in the warrant knows what meth is, although you could do that. If she tells the truth all the time, I'm wearing a suit, I have a white shirt on. That's two facts that could be corroborated as truth. But if I know what meth is, then it ought to be said in the search warrant. We cannot just say that we're going to have probable cause to intrude on people without specific reliance. And so we would ask the court to look at what was omitted as much as what was put in the warrant. As to the issue about raising in the brief about the expert testimony, we talk about it. We recognize that this court has never accepted that as a law, that the federal law does that, and we're just asking for a suggestion. But we are concerned about the statute because the state misconstrues what those statutes say. If I might read to the court. 3917-434 says it is an offense for a defendant to knowingly possess methamphetamine with intent to sell methamphetamine. And then it goes on to say in subpart C that a defendant shall be charged, indicted, prosecuted, and convicted under this section rather than 3917-417. So 3917-417, which for years has been our crucial prosecution statute, is no longer the prosecution statute for methamphetamine. And then 434E1 states that the punishment shall be provided as in 17417. But this is the language of 417. C1 says the punishment is a Class B felony, and I quote, if the amount involved is 0.5 grams or more of any substance containing methamphetamine. Clear. Part C2A provides that any other Schedule II controlled substance, including methamphetamine, not in a substance, but in an amount of less than 0.5 grams, is a Class C felony. So if the state cannot distinguish in their proof between the two of these, then it should be the Class C felony that Mr. Keyt was convicted of, assuming everything else that the state has done in this case is valid. And we understand where we are in that position. But we would ask the court specifically to not interpret this statute as saying any substance containing, because Part C, let me get 2A, says any substance, including meth, shall have this amount. And there's no proof in this record that there was anything but a substance containing 0.1 grams of the substance that included meth.
Thank you, Mr.
Thank
Jolly.
you.
We appreciate the parties' briefs and the arguments. The matter will be taken under advisement. I'd like to take a point of personal privilege, if you would. Today is not only National Punctuation Day, but it is also the birthday of our very own Judge Rob Montgomery. So I would just like to take a moment to wish him a happy birthday. He probably,
I appreciate that.
in his nature, he probably hates the fact that I'm recognizing him. But anyway, I just wanted to say that as a part of this panel. Are the parties for the earlier case present?
Yes, Your Honor.
All right, call that, oh, do we need a break? You good? You good? All right. The parties for the next case, please come forward. And Madam Clerk, call the case.
State of Tennessee versus David Alexander Hayes.
He looks worn out. Bless him.
Oh, yeah.
Yeah, here.
Good afternoon, Your
Should say
Honors.
something nice.